If you're dealing with the loss of a loved one, you might be asking, do I need probate in Florida? How long does probate take? How much does probate cost? And what exactly is the Florida probate process? In this video, I am walking you through the complete Florida probate process step by step, including timelines, costs, types of probate, and common mistakes to avoid. Probate in Florida is the legal process used to transfer assets from a deceased person to their heirs or their beneficiaries. When someone dies, their assets can't automatically be transferred if they were owned in their name alone. Probate ensures that debts are properly handled, creditors are notified, taxes are addressed, remaining assets are distributed according to a will or Florida law. Probate is not about taking property away. It's about legally transferring ownership. It's required when a person dies owning assets in their name alone without a designated beneficiary. Some common examples where you're going to need probate. Let's say a home is titled in the decedent's name, a bank account that does not have a pay-on-death beneficiary, a life insurance policy that does not have a beneficiary who is still alive, vehicles that are titled only in their name, investment accounts that don't have transfer on death instructions. However, probate may not be required for life insurance with named beneficiaries, retirement accounts with designated beneficiaries, jointly owned property with rights of survivorship, and assets held in trust. So the key question is whether the asset is considered a probate asset or a non-probate asset. Summary administration is a simplified probate process, and it's available when the estate has less than $75,000 in probate assets or the person has been deceased for more than 2 years. This process is typically faster, often 1 to 3 months, and may not require a personal representative. However, it still requires court filings and a judge's order to transfer the assets. Formal administration is the most common type of probate. It's required when the estate exceeds $75,000 in probate assets, the decedent passed away within the last 2 years. When real estate is involved, more than likely you're going to need probate. And if there are creditor issues, formal administration requires the appointment of a personal representative and issuance of letters of administration. It also requires notice to creditors, an inventory of assets, and then formal closing of the estate. The process of formal administration typically takes 6 to 12 months, depending on the complexity. So here's a general step-by-step process for formal administration in Florida. Step 1, we file the petition for administration. This document officially opens the probate case in the appropriate Florida probate court. Step 2, the court appoints a personal representative. The court reviews the petition and appoints the personal representative named in the will or determined under Florida law. Step 3, your letters of administration are issued. These court documents give legal authority to act on behalf of the estate. Step 4, your notice to creditors. So creditors are going to be formally notified and they have a limited period of time to file their claims. It's actually 90 days. Step 5, inventory of assets. The personal representative identifies and values probate assets on the inventory. Step 6 is paying debts and expenses. Valid debts, taxes, and administrative expenses are paid first. And then step 7 is distribute remaining assets. So after the debts are resolved, the assets are distributed to the heirs or the beneficiaries of the estate. Step 8, we close the estate. And the probate case is formally closed through court approval. Florida probate typically takes, like I said, 1 to 3 months for a summary administration and 6 to 12 months for formal. But probate may take longer if you have disputes between the heirs, the original will can't be located, there are real estate title issues, creditors file claims, or assets are difficult to identify or even maybe liquidate. The more complex the estate, the longer the probate may take. Probate costs in Florida vary depending on the estate's size and complexity. But typical expenses include your court filing fees. You're looking at about $400 if it's a formal administration. Attorney's fees, which can be a percentage of the estate value or it can be hourly, it depends on the attorney. Publication costs for creditor notice. This is dependent on the county because every county's publications, they have different pricing. Certified copies of court documents, appraisal fees to appraise and get valuations for property, A bond, if it's required by the court, has to be posted. Every estate is different, so costs really depend on some specific circumstances. But some common mistakes that delay Florida probate include distributing assets before the creditor deadlines expire, failing to secure the homestead property, not locating the original will, overlooking unknown debts, poor communication among heirs. Proper legal guidance can help prevent those costly errors. While probate may appear simple, many estates involve real estate, multiple heirs, blended families, disputes, creditor issues. Working with a Florida probate attorney can help ensure that the process is handled efficiently and correctly. Also, in many situations, Florida law requires an attorney. Hi, I'm Alicia C. Daniel, Trust, Estate, and Probate Attorney at Genesis Law. And if you need help navigating a Florida probate matter, click on the link in the description box and select Schedule a Consultation.